Welcome, everyone. Welcome to the noon meeting of the Rotary Club of Baton Rouge. Yes, this is still a hybrid meeting for those of you out there in Cyberland. Welcome. I'm Haggai Davis, your club president. We'll start off the meeting with an invocation led by Todd Sterling.
Thank you, Haggai. Let us bow our heads. Lord, thank you for bringing us together on this day. Thank you for everyone in this room and their unique gifts that they bring to Baton Rouge. Lord, I pray for our community's safety as we enter hurricane season. Help everyone to heed the warnings and do the things necessary to protect themselves, their families, and their property. Lord, I also pray that our community understands the realization, the safety, and understanding that the pandemic is still happening and that people do everything that is possible to protect themselves and their families so we can try to put this past us. Lord, I pray for our leadership of our state and our city of Baton Rouge. Lord, we also pray for the educators and the children as school closes and the summer begins. Lastly, Lord, I pray for our community's prosperity. In Jesus' name we pray, amen.
And the pledge will be led by Jacqueline Wilfong.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And the four-way test, Blanchard Sanchez.
Of the things we think, say, or do, is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned?
Okay, Donna Siraj will now introduce our guest.
And we have guests today. This is so exciting. I'm going to ask each of you to stand and everyone hold your applause till everyone is introduced, and then we'll give them a big Rotary welcome. George Bay, please stand. Phyllis McLaurin, you're right here, you can stand. Kevin Sasson, Judy Faust, Sandra Loy, John Haley, Kim Thomas, David Tidwell, and visiting us, a Rotarian from the Woodlands Rotary Club, Mark Vance. Let's give everyone a big Rotary welcome.
Okay, and this is what every club president loves, is to have an introduction of a new member. John Snow, will you please?
Good afternoon. It's my pleasure to introduce our newest member, a good friend of mine, Gaines Garrett. Gaines is the Vice President of Secure Shredding and Recycling. Since joining the family business in early 2017, Gaines has helped grow revenues more than 700% and established SSR as Louisiana's largest independently owned shredding company. Gaines is the only person in the state of Louisiana to achieve the designation of Certified Secure Destruction Specialist, which is a mouthful. This designation is awarded by the National Association of Information Destruction to management professionals who have demonstrated a high degree of expertise in data destruction operations, regulatory compliance, information security, and risk management. Under Gaines' leadership in 2019, SSR was named LSU's fastest growing Tiger alumni owned business, just ahead of Emergent Method. I promise I'm not bitter about it, Gaines. But in addition to his work with SSR, Gaines has been an entrepreneur since his time in grad school at LSU and is a partner in several companies developing products and services across multiple industries. Again, he's also a good friend, and I'm proud to introduce him to our club. Welcome.
All right. So your head table, from my right to your left, Jacqueline Wilfong, VP of Sales, Louisiana Capital Federal Credit Union. John Snow, partner, Emergent Methods. Garrett Gaines, our newest member, was just introduced. Blanchard Sanchez, partner, MacArthur Sanchez Associates. I'm Haggai Davis, club president. Shelly Dick, our speaker, who will be more formally introduced in a few minutes. Franz Borgart, owner, Borgart Law Firm. Todd Sterling, owner, Alpha Media and Public Relations, your head table. A few announcements. Vaccines for the second round for those who got the vaccines a couple of weeks ago will be in the room right over here at 1 o'clock. We had, I think it was 19 people who got vaccinated the last time around. So I'm really excited about that. Next Wednesday, we will be doing a blood drive here at Drusilla. And Offsite Fellowship is coming up June 30th. So we're going to be sending out a sign up on Friday. So look for the email and we'll get that taken care of. Next Wednesday, May 19th, our speaker will be Paula C. Davis. In my world, the real Paula Davis. She is going to be speaking about the myths of adoption and the impact of DNA, and also how registries affect adoption search. Everyone is welcome to join us on Facebook and YouTube Live as well. So with that being said, Franz, if you will introduce our speaker.
I was told very specifically 2 minutes or 350 words and then sit down. And the judge will tell you, me keeping my mouth shut is something I have issues with sometimes. It is my pleasure to introduce Chief Judge Dick. She was commissioned May 10th, 2013. Prior to that, she was in private practice with Foster Dick for 25 years. Prior to that, she was a graduate from the Paul M. Hebert LSU Law Center, where she was on law review. She is the chief judge, and today she will be talking about federal court during the pandemic. So, round of applause for Judge Dick.
Well, thank you, Franz. Yeah, kept it really short. Very good. And let me thank Linda Lightfoot for roping me into this. And thank you to the Rotary Club for inviting me to speak to you today. It's really a pleasure to be here. I recognize a lot of friends that I've seen recently and friends I haven't seen in a long time, and also colleagues in the practice of law, and it's good to be with all of you. As you may know, Linda tried to rope me into this last year, but the pandemic saved all of us from that experience. And I was going to talk to you about the RISE Reentry Court, which is a specialized court that the Middle District has. And I want to say a few words about that at the end of these remarks. But I felt like that coming out of the pandemic, I hope we're coming out of the pandemic. As you can see, we're slowly emerging, as you can tell by the numbers here today, that it might be useful and informative for me to talk a little bit about how the federal court here in Baton Rouge came through the pandemic, what we experienced, and where we are now. First, let me give you a snapshot. If you're not a lawyer, you may not know this. If you are a lawyer, forgive the primer. The United States District Court for the Middle District of Louisiana is one of 94 federal courts in the United States. There are 3 districts in Louisiana. The Middle District is one of them. The Middle District is right here in Baton Rouge. We're on Florida Street, across from the post office downtown. It's the Russell B. Long Federal Courthouse and Federal Building. It's a small court. We have jurisdiction over 9 parishes. I think I can list those: East Baton Rouge, West Baton Rouge, Iberville, Point Capee, West and East Feliciana, Ascension, St. Helena, and Livingston. I think I've gotten them all. As I said, we're a small court. We have 3 active judges, myself, Judge Brian Jackson, and Judge John DeGravels. In addition, we have 3 United States magistrate judges, one who is a member of your club, Scott Johnson. In addition to Judge Johnson, we also have Judge Walter Dooms and Judge Bourgeois. Small though we are very busy. We have a very extensive docket of federal, both civil and criminal litigation. And just to give you an idea, we have presently about 1,500 civil cases and just shy of 600 criminal cases. So per judge, that's about 187 criminal cases and about 500 civil cases. If those numbers don't mean anything to you, ask the lawyer at your table, because I'm sure there's one at every table, how significant that is. It's significant indeed. But despite the fact that we are few in number and we have a very large docket of some fairly complex cases, because we have things like the Capitol and 2 universities and the largest penal institution actually in America, in our district, we have a lot of complex constitutional litigation. Despite that, the last year that statistics were taken before the pandemic, 2019, the Middle District was the 6th most productive court of 94 in the country. That's something that we're very proud of. Thank you. I didn't do it. My colleagues did it. But so with that backdrop, that snapshot of what does our court look like, let me take you back to the 12 months and tell you a little bit about how we continue to conduct business of the court. On March the 13th, 2020, as the chief judge, I entered the first COVID-19 general order. Subsequent to that general order, we've had another 7 or 8 general orders dealing with court operations during the pandemic. A general order is just simply stated an order that prescribes how a court will operate. Generally, we have a couple of general orders a year. This last year, as I mentioned, we had 8 or 9. The COVID-19 general order, as you know, our general order, which was March 13th, followed a March 12th declaration by the governor of a state of emergency, a March 13th declaration by the President of the United States of a national state of emergency, and a declaration by the World Health Organization that we were, in fact, in a global pandemic. Not to mention the workings of the CDC trying to grapple with and provide us all citizens with guidance on how to deal with what they identified as a rapidly emerging situation. Against that backdrop, I ordered that our court postpone all criminal and civil jury trials until on or before May 1st. So it was middle of March, and I guess we were optimistic that maybe there was a silver bullet here somewhere and we were going to get out of this thing. We're going to be able to resume May 1st. Well, we know that didn't happen. I also ordered that all civil evidentiary hearings and in-court hearings be postponed until after April 20th. Grand jury proceedings were postponed until further order of the court. We suspended the Speedy Trial Act, which is very significant. Criminal defendants have a right to a speedy trial, and we suspended those deadlines. We also suspended the statute of limitation deadlines because people were going to be unable to meet those requirements. Initial appearances of newly arrested persons were ordered to be taken by video conference. Arraignments and sentencing. So when somebody pleads guilty or not guilty, or when they're sentenced, those were ordered to be performed by video conference or were postponed until further order of the court. Importantly, paper filings were no longer accepted. That's significant. We didn't know at that time, and none of us knew at that time, how was COVID-19, the coronavirus, transmitted. So we no longer accepted paper filings. Everything had to be fax filed or electronically filed. Well, as you can imagine, we have pro se litigants that represent themselves. So we set up a drop box at the front of the courthouse to accept paper filings and set up protocols for clerk employees to retrieve those papers so that people could make their filings if they didn't have the ability to use electronic means to make their filings. Fast forward a couple of weeks, by March 20th, the Congress passed the Coronavirus Relief and Aid Act, also known as the CARES Act, that the president also signed into law on March 20th. Most people in this room know that as a $2.2 trillion economic stimulus package, but embedded in the CARES Act was some very important legislation that allowed federal courts to continue to do their business in the circumstances of a pandemic. We had already ordered that we were going to proceed, either not proceed in person at all, or to the extent that we could proceed by video conference. March 20th CARES Act gave federal courts that authority. We kind of seized that kind of before we were given that authority. In the interest of health and safety, we weren't the Lone Rangers. Other district courts around the country had done the same thing, luckily, or fortuitously, and I think correctly. The United States Supreme Court and the Judicial Conference of the United States imposed upon Congress to allow federal courts to proceed in that manner. And so that's what happened under the CARES Act. So the CARES Act was when Zoom Court was born. And I'll give you a little bit of just some interesting stories about Zoom Court. First, let me share some of our pandemic operations from two vantage points. One, the criminal side, and the other, the civil side. On the criminal side of things, when someone is arrested on a federal crime, they must come before a federal magistrate within 72 hours to be informed of their charges and to enter their plea. Statistically, the vast majority, 99% of people who come within 72 hours plead not guilty. All of those proceedings after the pandemic and after the CARES Act was enacted were by video conference. Then after that, if somebody is if somebody has pled not guilty, a magistrate judge or a district judge has to decide, is this person either a risk of flight or a risk to the community? If so, they're detained. So they're put in jail pending their trial. The detention hearings were also held by video conference. After the detention hearings phase, an accused person decides, do I want to go to trial or do I want to plead guilty? If they plead guilty, that's another hearing where they're explaining their constitutional rights, the rights they give up to a trial by jury, et cetera. It's a fairly significant constitutionally derived hearing or mandated hearing. That was by video conference. And importantly, sentencings were by video conference. So if you can imagine the psychology for both the lawyers, the accused, and the judge, to deprive somebody of their liberty by video conference is a pretty significant thing. But that's what we did. And we did that for about 12 months. In the last couple of months, we've migrated more toward, and now we're almost 100% sentencings are in court. Guilty pleas are in court. We're still doing some detention hearings and some initial appearances by video conference. But what did that mean? It's easy to say, okay, we're doing all this by video conference. Well, that's just great. I have a monitor and a microphone and a video camera, but accused defendants don't. So the first thing that we did was, within a week of the CARES Act being enacted, when we realized that this was going to be probably a longer term situation, we deployed our IT department of the Middle District to the 3 jails that we contract with to hold prisoners. There's no federal Bureau of Prisons in our district. So the United States Marshal Service contracts with East Baton Rouge, West Baton Rouge, and Ascension to hold federal detainees, both pretrial and post-conviction, until they're designated to a Bureau of Prisons facility. Our IT department went to all 3 jails and installed video equipment, video monitoring, or video conferencing equipment. And then our clerk of court coordinated with the wardens of those 3 jails to set up systems by which inmates could be brought into a secure area, because these are private hearings. Jailers can't be in there when prisoners are talking about whatever their court hearing. So they had to arrange that. Well, that benefited us and it benefited detained defendants, but it also benefited the state court because the state court also used those video conferencing capabilities that your federal court installed in those 3 jails. That's something I'm extremely proud of. Our IT department was just absolutely valiant in that effort. And but for that, we wouldn't have been able to continue to do those hearings. And I guess the result of that would have been people languishing in jail without ever having come before a magistrate judge or a district judge. So that's what we did on the criminal side. Up until, so at this point now you have initial appearances, detention hearings, rearraignments, which are guilty pleas, and sentencings, all by video conference. In the last 14 months, we have done literally hundreds of those hearings by video conference between the district judges and the magistrate judges. As of today, as I mentioned, we are returning to open court, and we've migrated back to open court in probably 90% of those criminal proceedings. So you'll recall that we had a moratorium on jury trials. And the reason for that was that it's very difficult to provide for the general public's health and safety if you're bringing in 50, 60 people for jury service and going through jury selection and then exposing them to a week or 2 weeks or 3 weeks of trial. So did we have any trials, jury trials during the pandemic? We did. We had 2. We had 1 civil and 1 criminal. So I'll tell you a little bit about the criminal one, and I'll tell you why we had them, because it was, you know, it was dicey. We had a criminal trial. I presided over a criminal trial in August of 2020. And the reason that we decided to go forward with that trial was because in looking at the facts of the case, it was a gun charge, a federal gun charge. And honestly, it looked like that the defendant had a reasonable chance of an acquittal. But he was detained for reasons that are not really particularly relevant. So he was in jail in East Baton Rouge Parish. And my view of the file, of the information, indicated to me that he had a reasonable shot of an acquittal. So not knowing when this pandemic thing would wane, we decided to put some protocols in place and have a jury trial. And we did that. And it was not easy, but we did it, and we did it successfully. So I'll tell you a little bit about what we did to do that. We summoned 60 people. We sent out a jury questionnaire with a summons that allowed them to disclose to us if they had particularly they didn't have to tell us what their health risks were, but were they at risk of COVID-19 or coronavirus contraction? Or had they recently had coronavirus or COVID-19 such that they would not be appropriate, it wouldn't be appropriate for us to ask them to serve on a jury. We excluded those right off the bat. Subpoenaed some more until we got a venire, which is your pool of about 60 people. Well, we couldn't bring 60 people in at one time, so then we broke them into 3 heats of 20. We brought them in 20 at a time, 2 hours apart, and did jury selection. Literally did jury selection twice. We were able to get our jury after the second heat, but the second wave of jurors, but we had 3 panels on ready. So the first panel comes in at 9, the second panel came in around 11:30. We issued each juror, well, first we did COVID screening questions at the door. We took their temperatures at the door. They gathered socially distant. The jury coordinator asked them more COVID questions. They watched a video about the safety precautions that our federal court had instituted for their benefit. They came upstairs, they came in the courtroom, they were socially distanced in the courtroom. They weren't just seated in the jury box, they were seated throughout the gallery. They were issued a little personal bag that had in it a mask, a shield, hand sanitizer, a pen, and paper, because I allow jurors to take notes. So they each had their own pen and paper that they didn't have to share. During jury selection, they were able to use the shield so that the lawyers could see their faces, and they answered the questions that were posed to them during jury selection. Everyone else in the courtroom, me included, were socially distanced. We wore masks. There was plexiglass everywhere. I'm sure you've seen that. I wish I was a plexiglass manufacturer owner. And we got our jury after 2 rounds of jury selection. Another way that our IT department came through. Typically in jury selection, we pass around a microphone when it's a juror's time to speak or answer a question or respond. It's a big courtroom and there's a lot of people in there and there's high ceilings. And so it's amplified with microphone. Well, I can't hear on the bench a juror that's across the room, and they're usually soft-spoken because it's kind of an intimidating situation. So our IT department harvested old cell phones from literally around the country, old iPhones, wiped them clean, and installed an app where they could use the cell phone as a microphone. So a juror was given a cell phone that was in a clear plastic bag that had been disinfected. It didn't have any data on it, but when they pushed the button, it amplified through the speakers. So each juror had one of those. So we didn't have to pass a mic. I mean, I'm telling you, these IT people are geniuses. Present. So I've already said everybody else was in masks. Once the jury was seated, they were seated socially distanced. We had 4 in the jury box and the rest were in the gallery. Well, when your gallery is filled up with jurors, then you can't have anybody else in the gallery. So if there was media or a family member or an onlooker, a lot of times we had law students, we opened a second courtroom with a video link to that courtroom so that people that were spectators could go in that courtroom. When a witness was called to testify, they waited in their car. They were texted, or we texted them, the lawyer or the courtroom deputy would text them that it was their turn to testify, and they would come in the building. And that way we limited the impact on the building of the number of people. We had plenty of space, but we wanted to limit the impact on the building for the rest of the employees of the building who were teleworking and coming in kind of in waves. Long story short, we went a week. The jury deliberated in the courtroom. They usually go in the jury deliberation room. They weren't able to do that, so the lawyers had to get their stuff and get out, and we sealed up the courtroom and let the jury deliberate in the courtroom so that they could use the space to be socially distanced. At the end, I surveyed the jury and asked them how they felt about it. They were very appreciative. They felt very safe. They felt very comfortable. They were grateful for the experience, and we had no adverse outcomes. No court person became infected, no lawyer, no witness, no juror. So all in all, it was arduous and it was difficult, but we were able to do it. And we did the same thing with a civil trial. Fewer jurors, you only need 6 for a civil jury trial, so it was a little bit easier in January. So we did do, as I say, 2 things. So despite the sizable challenges that we faced, I think we've done a pretty good job of keeping things going. In the 14 months that we've had kind of curtailed in-person proceedings, we've continued to move the docket. We've had 521 cases that were either resolved by some dispositive action of the court or through settlement. Unfortunately, in the 12 months from March to March, we postponed 135 jury trials. That's a lot, and we have to get those back on the docket. Right now, we're in catch-up mode. Between May 1st and December 31st, we have 143 jury trials on the books. So if you do the math on that, there's 3 judges, so that's 48 trials per judge in 35 weeks. So I don't know. I'm going to clone myself, I think.
No vacation.
Yeah, no vacations. So I'll give you a little bit of information about bankruptcy and probation and how they handled the pandemic, and then I'll give you a few war stories that might round off this with a little laughter. Bankruptcy court as well. We have a bankruptcy court with 1 bankruptcy judge, Judge Todd. They went to complete virtual. In the practicing bankruptcy bar have expressed to Judge Todd that they prefer the virtual proceedings. And it lends itself to virtual proceedings because it's not terribly witness intensive, and there's no juries, so it lends itself to that. So that may be something that continues in the future. The one distinction that bankruptcy court experienced that was a little bit more difficult than district court is they have a lot of pro se litigants, a lot of debtors that represent themselves and come to the bankruptcy court to try to defend themselves against creditor action and that kind of thing. Those folks, a lot of those folks don't have the resources to file electronically or to fax file. So the clerk of the bankruptcy court set up a call system, a phone tree where somebody that needed to file in person, the clerk of court literally met them on the courthouse steps and accepted their filings to accommodate those people so that they would continue to have the access to justice that they're entitled to and that they deserve. So I'm really proud of the way the bankruptcy court rose to that occasion. They made it work for the litigants that come before them. The probation office. Probation on March 13th, when we first went into this COVID situation, the probation office had about 350 post-conviction people that they were supervising, people who have already come out of jail, but they're on some sort of supervision for some period of time. Usually it's 3 to 5 years. They also had another between 50 and 60 pre-trial, so people that were not detained. If you are found not to be a risk to the community or a risk of flight, you can stay out of jail pending the resolution of the criminal charges against you, but you're supervised because we're keeping our eye on those folks that have been accused of a crime to make sure they don't become a risk to the community or that they don't become a flight risk. So there were another 50 or 60 people that probation was supervising that were in that capacity. Well, that's a hands-on, eyes-on, face-to-face endeavor, a difficult thing to do in the circumstances of a pandemic. So probation, again, used technology. They used Google Duo, they used FaceTime, they used Zoom. One of the things that I thought was just really remarkable, there's a number of either accused that are post-conviction or pre-trial that are on ankle monitors. Well, you can't send a probation officer into somebody's home in the height of the pandemic to get all touchy-feely and put an ankle monitor on them. So they use some technology called SmartLink that uses geotagging and real FaceTime recognition. So somebody can't put somebody else's face on and say that's them. No, it recognizes their face and it tags them geographically. So the probation officer knows exactly where they are. We use that a lot for sexual predators and sexual offenders. With that technology, the probation officer could tell you if they were across the street from a school, and we could send law enforcement to apprehend them. So they used some amazing technology to get to continue to do the work that they do, and so far we're very pleased with the results. They too, like the rest of the court, are going more and more back into real-time, face-to-face supervision. I'm happy to report that our court is about 80% vaccinated, so we feel really good about our health and safety. We will continue to require masks and social distancing for the protection of the public that we serve, and we continue to do COVID screening at the door. But in terms of our own health and safety, I'm really pleased that I feel like that our court family is in a good place. So I do have a few war stories, so to speak. You all saw the cat and the lawyer video viral thing. Well, I don't have a cat and a lawyer, but I have good ones. I have parties that did really weird things, and I have lawyers that did really weird things because lawyers always do weird things. And and I used to be a lawyer, and I still do them too. So, stories about parties. I was privileged to be presiding over a guilty plea of a lady who was charged with distributing large quantities of drugs in a state penal institution. So you can imagine Those are serious charges, and she was getting ready to plead guilty to those serious charges. She was out on supervision. She had not been detained because a magistrate judge had concluded that she was not a risk of flight, nor was she a danger to the community. So she was coming by video conference to give her guilty plea. I called court on Zoom. The lawyers made their appearances, and I'm looking at the lady, and she's moving all around, and her phone's moving all around, and you hear rustling, and I'm just about to say, ma'am, are you somewhere where you can sit down and answer some questions and pay attention to these proceedings? This is serious. And I didn't even get the first word out of my mouth, and I hear, shh. I was like, ma'am, where are you? Oh, I'm in the restroom at the Cracker Barrel. I'll be right with you. Can you hold on while I wash my hands? Puts the phone down. I'm like, we'll be doing this another day, and you'll be in your lawyer's office, okay? Okay, so my personal favorite involves one of your own members, Lane Ewing. He's not here today, probably because he knew I was going to talk about him. Lane was handling a video detention hearing that was contested, so he was going to have to call witnesses. So one of his witnesses was on the screen. She wasn't testifying yet, but she had her cell phone, and she was in the bathroom, and she was putting on her false eyelashes. I guess she wanted to look good for the camera. So I think Judge Johnson was presiding over it, and he let it go, which is okay. He's more patient and kind than I am. So when it came time for her to testify, she looked beautiful, and she was testifying. And then she was Zoom bombed by her daughter, who was jumping on the bed behind her. So it's always something. The lawyer stories. Well, let's see. There was the lawyer who was dipping tobacco during a video hearing and excusing himself while he spit it in the cup. And then I had a lawyer who decided that it was time to eat a sandwich during a hearing. And it wasn't even lunchtime. And then there was the lawyer who was doing a contested hearing, a detention hearing, calling witnesses, offering evidence, saying, Judge, I'd like to offer as Exhibit A. I'm going to screen share right now, while this lawyer was driving his mother to a doctor's appointment. So, but then there are cases where the judge strikes back. So one of my colleagues had several experiences with a lawyer that did these kinds of things, and they had been repeated. And so he got ready to call the case on another video conference, another video hearing. And this particular lawyer who had been not quite as diligent as maybe he should have been several times, the judge decided, I think I know what to do. And he said, Mr. Lawyer, I'm going to need you to stand up. I want to verify that you've come to court with trousers on. So those are the pandemic war stories. I was just going to call for questions. You get to be the first one. No, because my skills at prediction are not very good. No, he was guilty. No. Other questions?
That was the most pressing.
It was. I knew somebody was going to ask it, so that's why I left it out.
Your Honor,
Yes, sir.
do we have a Dr. Bull in Baton Rouge?
A Dr. Bull. I don't know a Dr. Bull in Baton Rouge. I don't watch. Is that a court TV thing? Oh, I don't watch it. Sorry. I watch about that much TV, y'all.
So does a lawyer have pants on?
I didn't get the answer to that part. I don't know. He may not have stood up. I would love to. Would you like to hear a little bit about it? Okay. Oh, she would like to hear about the RISE program. It's actually a reentry court program. We have a specialized court in the Middle District that we started in 2016. It's called RISE. It's rehabilitating individuals through strategic encounters. What we do is we take 6 to 8 people who probation has identified that are going to be released from a federal Bureau of Prisons into the Middle District, and we put them through a reentry court. I'll tell you a little bit about the court, and then I'll give you some of the statistics that bear out why we do this. If you're admitted into first of all, you have to apply to go into the reentry court. So probation is going into the Bureau of Prisons and identifying people that are going to be released, because they're going to come out on supervision. So we know who they are. They identify people who have taken a battery of psychological tests and have demonstrated that they're at a high rate of recidivism. They have a high risk of recidivism. Those are the ones that we want. So we take 6 to 8 a year. They come to court every 2 weeks for the first 6 months and every month for the next 6 months. They are intensively supervised. There's more intense supervision by the probation office than somebody who's not in reentry court. They go to cognitive behavioral therapy once a week with a licensed clinical psychologist. If they need individual counseling, we provide that to them. Their cognitive behavioral therapy is a group session where they're given some cognitive behavioral tools to make good decisions, because that's where the problem is in the decision making. During reentry court, we identify obstacles. We have each person come up and I preside over it, and one of the magistrate judges, Erin Wilder-Dooms, preside over it. And we ask them, how are you? Are you working to have to work to be in the program? How's your job going? How are things in your family? What obstacles do you have? They identify obstacles and we fix them. We don't fix it for them, but we show them, this is how you do it. I'll give you an example. Judge, I have a job. I'm working as a pizza delivery guy, but I really need a better job. And I can get a job at a plant, but I can't get my TWIC card. Well, let me tell you, we counsel them and we talk to them and we show them, how do you get your TWIC card? Here's the secret. You have to apply more than once, but you can get your TWIC card. Or they'll say, Judge, I have six uncleared traffic citations and I can't get my driver's license. And if I don't get my driver's license, I can't get to my job. The federal public defender, we say, help this fellow, go call the DA and see if they can clear those warrants. So they do, they clear the warrants and he gets his driver's license. Or, my kid's acting out in school. We get a family guidance person in to talk to them and help them. These are people that have been out of their communities and out of their families, some of them for 10 and 15 years. And they come back and they want to be dads, or they want to be moms. They want to be spouses. They want to be good employees, but they have obstacles. So we work with them on that. Why do we do that? Well, statistics show that 16% of people are going to recidivate in the first year. So if you can get them in the first year, you can break that cycle. It costs about $33,000 a year to put a person in the Bureau of Prisons, but it costs $53,000 to revoke them and send them back to jail if they mess up and recidivate. And that's because there's process that has to happen to send somebody back to jail because of a supervision violation. So in 5 years, this community, if we can keep the 8% of people that are identified as high risk of recidivism, if we can keep them from recidivating, if we can keep 90% of them or 80% of them from recidivating, we can save this community, your federal tax dollars, $850,000. You know what it costs to supervise them? $341 a month. I mean, it costs $4,000 a year to supervise. That's where we need to spend our money. And so that's what we're doing. It doesn't cost any more. The other judge and I do this on our lunch hour. And we've had, I wish I had the numbers in front of me. I think we've had 24 graduates. We've had tremendous success. Of those, 17 are successful. Some are back in jail, but 17 were successful. If we save one, we're going to save $53,000 a year. So it's a great program. What can you do? You can be aware of it. And if you have an opportunity to hire a formerly convicted felon, think about it, do it. Particularly federal ex-offenders, they are being supervised, and they're being supervised intensely by United States probation. Our probation officers have a caseload of 80. They don't have a caseload of 900. They're seeing these people every week. They're talking to them every week. They're going to carry a lot of the HR burden. We're drug testing them. If you're drug testing them and you have a reason or an opportunity to hire somebody, we'll drug test them for you for free because we're drug testing them anyway. It's really, those are the big things. Be aware of it. If you have an opportunity to mentor somebody that's coming out of prison, if you want to get involved in our reentry court, I'll give you my name and my phone number. I'll give you my cell phone number. We'd love to have you. Come give a speech. Come talk to them. See if you can help them clear some obstacles. If you have those kinds of social skills, social service skills, we'd love to have you. Any other questions? Thanks for asking that.
Meeting adjourned.